Now, X wants the presence of President of India as a witness in a civil suit. Can the court issue summons to him? Actually, Order 16 of the Act deals with the issuing of summons to a witness, where after receiving the list of witnesses from the parties, court will issue the summons to all the persons who are staying within the limitation jurisdiction of the court, and if any person is not residing within the jurisdiction of this court, then summons will be sent to the court in whose jurisdiction this person is staying, and President of India and Governor are not covered, expressly not prohibited by this, but actually they both got the exemption as per the constitutional provisions. Article 361 bars to issue any proceedings against either governor or president. So, court cannot issue the summons to them. Those provisions we have to mention here. And the next one is about EP. EP covered under Order 21 of the Act, and where A filed a EP against B, and he sought for attachment and sale of property of B. He further prayed for the arrest of B. Can he do so? Definitely he can do so. And in a execution petition, you can ask for the arrest of the party, you can ask for attachment of the property, and you can ask for appointment of a receiver, and therefore absolutely you are having that right. And X discharged a time bound debt, and later after realization, now he wants to file a suit. So time bound debt means actually according to Limitation Act, when a particular procedure is time barred, you cannot get any relief in the court of law, but that right still exists. So, when a debt is time barred, your right to get that amount is still in existence, but you lost the opportunity to file a case for recovery in the court. But when the other party himself comes forward, as explained in section 17 of the Act, and acknowledges the debt, then from the date of acknowledgement, the limitation will extend. Therefore, even though it is a time bound debt, he paid the amount and he did the signature relating to it. That the moment he accepted, he admitted and paid the amount, the limitation again starts. Therefore, now he cannot ask for the repayment of the loan amount which he paid. So he cannot file a suit for recovery of the amount, as he voluntarily came forward to pay the amount. And the next question is that the limitation period for filing a suit is 3 years. However, the plaintiff was imprisoned during the period of such 3 years. So, 3 years period when he is in jail, he is unable to file the case. Can he do so after coming out? Definitely, this is called legal disability. When a person is, section 6 of the Limitation Act deals with this. When a person is legally disabled to initiate any proceedings, then after coming out of that disability, he can file the case. His limitation will start then again for any lunatics or minors, persons who are imprisoned. All these persons, this particular section 6 of the Limitation Act is applicable. X wants arrest of the defendant in a suit for recovery of immovable property. Can he do so? Arrest of a person in a civil suit. Definitely, he can ask for the arrest of the person under certain circumstances. What are they? Go through the provisions of Order 38. According to that, arrest of a person before the judgment. When that particular person who is against whom the case is filed is trying to uh, alienate the property in the name of somebody else, or he is trying to dispose of the property, or when he is creating any kind of obstructions to the proceedings of the case and non-cooperation in continuing the proceedings like this. If any problems are created by you, then he can be arrested by the court on the application receiving from the other party. When he deposits some security in the court relating to this subject matter, then court may stop arresting him, otherwise he will be arrested. And A filed a suit for declaration. In his pleadings, he has omitted certain facts and committed certain mistakes inadvertently. Now A wants to rectify his pleadings advice. Pleadings can be amended at any stage with the permission of the other party. If prior to written statement, if pleadings are amended, then it will be easy. But after the yeah, written statement, when the party wants to amend the pleadings, then the permission from the other party also is required, notice to be issued to him. And if he is having any objections, he will raise those objections. Then court will take a decision to amend the pleadings. However, Order 6, Rule 16 and 17 says that amendments can be carried out prior to the commencement of the trial, and court must feel that these amendments are required for the finding out of the real facts of the case. So it is possible. And if he fails to, if the party for whom that order is given fails to comply with the order, then he cannot get a chance to continue. Next question is about the jurisdiction of the civil courts. Actually, A filed a suit against B for a recovery of 5 lakh rupees in junior civil judge court. Previously, junior civil judge courts are having only 1 lakh rupees jurisdiction. Now it is increased to 6 lakhs. Hence, case can be filed there. A filed a suit for a recovery of principal amount based on promised note. Later, he wants to file a suit for interest. A separate suit cannot be filed by him later stages because it will be barred by limitation. When at the time of asking for the principal amount, if he issued a notice relating to this interest also, and if the in the suit itself he mentioned about the interest also, then if he fails to get the judgment relating to interest, there he can file an appeal relating to the interest. That appeal suit is maintainable. But if he is not at all asking the relief relating to interest from the beginning, and now after completion of the case if he wants to file a separate case for interest, then it is not maintainable. And X resides in Vijayawada and Y resides in Vizag. Y borrows 5 lakhs from X at Hyderabad and executes a promissory note to X and agreed to pay at Guntur. Y fails to repay the loan. X wants to file a suit in Vijayawada. Advise X regarding the places where he can file the suit. So, place of suing. Next one. Promissory note. Where to file a case relating to a promise note which is executed at different places. Here, promisor, promisee both resides at different places, and it is executed at some other place, and finally where they want to file the case. X resides in Vijayawada and Y resides at Vizag. Y borrows 5 lakhs from X at Hyderabad and executes a promissory note to X and agreed to pay at Guntur. Y fails to repay the loan. This is relating to the jurisdiction, place of suing. Sections 15 to 20 of CPC related to the place of suing of a case. Generally, it will be the place where the defendant resides or the place where the promissory note is executed. So here, he wants to file at Vijayawada where plaintiff resides. It is not the place. Hyderabad or Vizag. In both these places, he can file the or Guntur because uh, he resides at Hyderabad, borrowed at Hyderabad, cause of action arised at Hyderabad, and resides at Vizag and paid at Guntur. So Hyderabad, Gunturlo cause of action arised, and he is residing in Vizag. So in these three places he can file the case. Okay. Next one, A is a too poor to pay requisite court fees. He wants to file a suit without payment of court fees. Is there any exemption to court fees? Definitely, there is an exemption to court fees. He need not pay. As per the Act, if you go to legal aid organization and if you submit an application, there they will exempt him from paying the court fees. Previously, uh, when they are exempting the person from paying the court fees, uh, they give the exemption, they ask the income certificate and other details. If the party furnish all the records, then court, this as a organization takes a decision and gives a exemption certificate. And after bringing that certificate, any advocate can represent the party and we can file the cases in the court. But presently, if a person is really not affordable to this court fees, then he is supposed to file an application before the legal aid authorities and they only will provide an advocate. If you are ready to continue the proceedings with the advocate provided by the legal aid, then only they are exempting the court fees. Otherwise, court fees exemption is not providing to the parties presently. So X is enjoying peacefully the government property for more than 30 years. The government wants to file a suit against X for recovery of the property. 30 years, 40 years, whatever may be the number of years, he is enjoying the property without any rights. So he cannot get the right over the property. Okay? No adverse position. One, if a suit is dismissed for default. When a person files the case, Order 9 of the Act deals with the uh, dismiss for default and ex parte orders. After serving the summons to the defendant, if a plaintiff fails to appear before the court and the defendant alone appears, then the suit will be dismissed for default. If the defendant appears and plaintiff fails to appear before the court, then it is ex parte orders. In the absence of defendant, orders will be passed. Here, dismiss for default means orders passed against the person who filed the case, that is against the plaintiff. So, it bars his right to file a fresh suit because he failed to attend before the court. But, however, he can go for requesting the court to uh, reopen the case. There, if a court satisfies with the reasons, then court may reopen the case and he can ask for the set aside of the orders. Notice will be issued to the other party, and after hearing the objections from the other party, court if satisfies, they will set aside the dismissal orders. Case will be heard again. And suit against GHMC. Next one. So here it is order 27 of the CPC. When you want to file a case against any corporation, you have to file against its commissioner or secretary, uh, and court may direct them to appear personally or may exempt them from appearing before the court personally. A notice is compulsory in all the cases where we are filing a case against the government. Suits X is an indigent person. He wants to file a suit against X. X is an indigent person and he wants to file a suit against X for recovery of. Someone wants to file a suit against X for rupees 1 lakh on a promissory note. What is the procedure that he should follow? Against X for recovery of. So if he is an indigent person and he wants to recover the amount, there will be absolutely no problem. There seems to be question correct, but anyhow, I will explain about suits to be filed against indigent persons. A person who is not having sufficient means to maintain himself is called indigent person, and a person who is having more liabilities than assets will appear before the court and he will file a petition there and request the court to declare himself as an indigent person. And if court declares him as an indigent person, he need not pay the amount. We cannot recover the money from him. And if it is proved before the court that he is having sufficient means, he played fraud on his part and obtained the false degree, or later stages, if he again gets some money, then we can approach the court and court will cancel the order. He is liable to pay the amount. Next one, how and when a person rights to property extinguishes under the Indian Limitation Act. The last question is that Limitation Act, how and when a person rights to property extinguishes under the Indian Limitation Act 1963. For this, section 23, sorry, section 27 of the Act says that general rule is that limitation only bars the remedy but does not extinguish the right to the sue itself. So your right is going to be in existence only, and section 27 is an exception to this rule. According to this, it takes about the adverse possession. In the adverse possession, we are going to lose the right over the properties. దీనికి కూడా actually latest case laws are there. Against the original owner, this adverse possession is not applicable. When one person who is having the possession over the property of other persons and that possession is extended for a long period, then he is going to get a kind of legal right over the property. So it is not only limited to physical possession, but also it includes de jure possession also.